regarding inmate Nino Neely, number 373601's preliminary hearing has been waived.
Good morning.
Good morning, Mr. Player.
Yes, ma'am.
We're here today for your revocation hearing, so we're going to get started with that, okay?
Yes, ma'am.
Good morning, I'm Peter Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Player Levion number 245010. Today is June 9th, 2026. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing and public access to the hearing is available via video live stream. Please state your full name and DOC inmate number for the record.
Levon Player, inmate number 245010.
You have counsel here today?
Yes, ma'am.
Morning, Attorney Alfonso Sirico from the Parole Revocation Unit on behalf of Mr. Player.
Good morning, sir.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole since releasing you, place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am.
We will now review the charge, the state your appeal is bringing against you, and the information underlying each charge. So charge one, or restriction reporting, your charging officer reported at 3/17/26. This PO spoke to you on the phone and instructed you to report to the Waterbury Parole Office on that day, 3/17/26 at 10:30 a.m. A subsequent text message was sent to you affirming the instruction. You failed to report as instructed. Charge two, under restriction GPS. Your charging officer reported at 12:10/25 at 3:27 p.m. there was a strap violation with your GPS unit indicating you cut off the GPS unit from your person. You reported to Waterbury Parole on 12/11/25 and a new GPS unit was strapped to your ankle at 2:08 p.m. Your whereabouts were unknown until that time. On 3/3/26, your GPS unit was shut down on 9:17 p.m. after failing to properly charge your GPS unit. It remained shut down until 3/4/26 at 2:59 a.m. Your whereabouts were unknown during this time. On 3/17/26 at 6:04 p.m. there was a strap violation with the GPS unit indicating you cut off the GPS unit from your person. The GPS unit subsequently shut down on 3/17/26 at 10:45 p.m. Your whereabouts have been unknown since that time. Charge three, residence. On 3/17/26 you left your residence and failed to return. Your sponsor has confirmed you have not returned to the residence. You do not have permission to move and you do not notify your officer that you are moving your residence. Your whereabouts have been unknown since that time. Charge four, reception absconder. Your charging officer reported at 3/17/26. You left your residence and later that day removed your GPS unit as indicated by the strap tamper alert. You have since failed to return to your approved residence. You have failed to call your parole officer or report to parole. All phone calls and text messages to you have gone unanswered. The exhibits your intent to voluntarily evade parole supervision. Your whereabouts remain unknown. Charge 500 of bail was drugs. Your charging officer report on 11/25/26. You tested positive for cocaine is confirmed by Premier Biotech Labs. On 2/20/26, you tested positive for cocaine is confirmed by Premier Biotech Labs. Charge 6, under no consumption of alcoholic beverages. Your charging officer report on 11/25/25. You admitted to alcohol use and signed a voluntary admission form. You also tested positive for cocaine is confirmed by Premier Biotech Labs. On 12/11/25, you admitted to alcohol use and signed a voluntary admission form. On 1/15/26, you admitted to alcohol use and signed a voluntary admission form. On on charge 7, behavior management program, your charging officer reported on 3/24/26, you failed to attend your domestic violence group, Explore. This was your 4th absence, resulting in your unsuccessful discharge from the group. And the state has filed the following exhibits that are pre-marked for identification as Exhibit A, remand of custody order; B, parole condition; C, parole violation report; D, notice of parole violation; E, state of Connecticut BOP decision information summary; F, state of Connecticut BOPP rev hearing summary; G, state of Connecticut BOPP rev hearing summaries; H, Premier Biotech Lab final reports; I, misconducts; J, voluntary admission form; K, one more behavioral health discharge summary; L, one more behavioral health email communication positive drug screens; M, judicial branch Explore discharge report; N, L, universal offender violation summary; O, GPS agreement; in P is PCS residential services unit progress report. Did you receive the notice of parole violation report, and those other documents I marked? Did you review them, sir?
Which was the ones with the program?
Talk about the reports, Levon, from
Wellmore?
Wellmore, yes. I believe.
I think I actually, you said you told me you got all the evidence, correct?
Yes.
Okay, that's all she's asking you, if you received.
Yeah, I'm just asking if you got those documents I just stated.
Yes.
Okay. And there is a addendum that was received. The addendum states on 4/6/26, the Board of Pardons and Parole did issue a parole absconder warrant for player. And on 4/8/26, the parole absconder violation was transferred to FIU. On 4/17/26, FIU was notified player was apprehended by the New Haven Police Department with no criminal charges pending. And council has filed the following exhibit pre-marked for identification: Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
And we have no witnesses today, so it is now defense's opportunity, if you'd like to call witnesses, present evidence, speak to any of the evidence submitted at this time. Yes. Mr. Player, can you please raise your right hand? I'm going to swear you in today so that you can speak. You solemnly swear or sincerely affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
All right, good morning, Mr. Player.
Good morning, sir.
Okay, so according to the violations brought forth by your parole officer, you were released on parole on April 10th of 2025, correct?
Yes.
Okay, and it appears, besides your sobriety as written in the narrative, you were doing fairly well at that time for a
Yes.
while you were out? Okay.
Yes.
And while you were out in the community, Mr. Player, were you dating anyone?
Yes.
Okay, and I don't want you to put her name on the record. Regarding her status, was she also on parole?
Yes. She was on probation. She was on probation, but me and her had the same, my PO, she had my PO before I had her.
Okay, she was on probation, and now you've been in since April 17th of 2026. That relationship you had with that individual while you were out in the community, she was using illegal substances, correct?
Yes.
And her using led you to a path of relapse also, correct?
Yes.
Okay.
That was like, this is the first time I've been in jail where I feel relief. Like trying to help her, I was just dragging myself down.
Okay. And regarding the, on March 17th of 2026, as far as reporting, on that date, you already knew you were going to be remanded. Is that a fair statement?
Yes. When she called my phone the night before, it was raining, and what happened was me and my girl, my sponsor is my cousin, And she knew that my ex-girlfriend wasn't no good for me. And I came home and I was with my ex-girlfriend and she was like, "Oh, you keep bringing her here. She's no good for you." So she called my PO, but my phone wouldn't, I couldn't scroll up for some reason. The phone, I guess it wouldn't scroll up because of the rain. So I talked to my PO on my sponsor's phone. And yes. And she called me so she told me to be at her office at 10:30, and I was thinking about it and I'm like, oh, I'm going to jail. And then my ex-girlfriend's telling me she's pregnant and thinking of going back to jail, knowing that I really have nobody, and my sponsors at this time is upset with me because I'm letting myself go with dealing with this female. So I'm like, I'm going back to jail where I lost my family and I have nobody. So I waited. I wanted to go, but I just thought about coming back to jail, and
I appreciate your honesty. That charge number 2, Levon, under GPS, I know you admit you didn't remove your GPS, but you did the next day, you did call, it was you took the initiative to call the parole officer to go be fitted with another unit, correct?
Yes, I went back home. I was the same situation. The female took my phone. I stayed out on looking for her, trying to find my phone because I have sons and family members that was calling me from prison. And I'm not gonna lie, I started drinking and I did cut the bracelet and I went back home. And when my PO called me, they knew I was home and she told me to come in. I went right in when she told me to.
Under the residence, I think you already beat me to it. As far as it indicates on March 17, 2026, you left your residence, and this is your sponsor confirmed you had not returned to the residence. Your belongings were still there, correct?
They're still there now, and she's still my sponsor. Long as my relationship is over with the girl, which she's in Niantic. My sponsors, they're here for me to give me support. I talk to them every day. They telling me that, their jobs at Home Depot and stuff like that.
We'll get to your background part at the second part of the hearing, Levon. But regarding the sponsor, the issue the sponsor had wasn't with you, it was with the girl you were dating at the time, correct?
Yes, sir.
Okay. And the absconder charge, the hearing examiner indicated you got picked up in New Haven, but you did not pick up any new criminal charges while you were out in the community and while you were off the grid for about a month?
No.
Okay. Under charge number 4, I know there's 2 parts to that. I'm going to ask that a no finding be made. The first one, I believe, is an impossibility. The date hasn't occurred yet. It's listed as 11/25/26. So I ask that a no finding be made on that. Regarding the charge number 7 under behavioral management program, that exhibit, I believe it's exhibit M, the 2-page report. I know the front page under absences, it lists 4. Second page, unless I have something else, I only see 3 unexcused. I didn't think that they used excused absences against our clients, but that I only see 3 dates listed. So there's 4 to be removed, but only 3 are listed. So I'm not sure why he was removed. I know, for absences, but I'm only showing 3 unexcused, and he did have one that was excused. I just wanted to bring you that to your attention. And regarding, this issue with which is charge number 6, exhibit L does indicate from the Wellmore program, from Mr. Poole to his parole officer, it says he started in December 5th, 2025, referred to the alcohol intensive outpatient group and was consistent with attendance up until his exit from group on 1/15/26. I don't run this group, but it appears he went to the App Foundation at that time. So he was in that program, removed from there. He did go to the App Foundation, and I will concede he completed it, but then there was an issue the day after he was released. But he is trying as far as dealing with the alcohol and the drug issue, he did successfully complete the APT Foundation. But he was going to Wellmore, and indicated by the senior clinician there, he was attending consistent, was there up until he went to the APT Foundation. I just have one moment. All right, I don't have anything else to add for the first part of the hearing, but I do want to be heard about his background at the appropriate time.
So I'll be right with you, with my findings. All right, so I'm gonna announce my findings. So regarding charge 1, I do find you violated condition of restriction reporting. This is based on evidence provided as well as testimony. This is exhibits based on exhibits B and D. On charge 2, I do find you violated condition of restriction GPS based on evidence provided in support of that charge, which is exhibits B, O, I, and N, as well as testimony. On charge 3, I do find you violated condition restriction residence based on evidence provided in support of that charge, exhibits B and D. On charge 4, I find you did violate condition restriction absconder based on a warrant being issued by the BOPP and evidence that was provided in support of that charge, exhibits B and D, as well as testimony. On charge 5, I do find you violated condition, obey all laws, drugs. There is a partial no finding on the future date of 11/25/26. This is based on evidence provided B, H, and I. On charge 6, I do find you violate condition, no consumption of alcoholic beverages. This is based on evidence that was provided in support of that charge, which is exhibits B, H, I, and J. Regarding charge 7, I do find you violate condition behavior management program based on evidence provided, exhibits B and M. So that includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, on behalf of Mr. Player, my client is 47 years old. He does have 6 children. One is 14 years old and the rest are all grown adults, and 4 grandchildren. He is active in all of his children's life. While he's been incarcerated, he's had some significant losses in his family. His mother, grandmother, and his younger brother passed away, and Mr. Player is an active person in his nephew's life since his dad passed away. He has, as far as his housing, since been out in April of 2025 to August of 2025, he was at the New Opportunities Halfway House, the Bishop House in Waterbury. Looks like in August 2025 to October 2025, he did successfully complete the APT Foundation Residential Services Division Inpatient Substance Abuse Treatment in New Haven. Then he was sponsored by his cousin, Ms. Slate, in Waterbury. And once again, he did the APT Foundation again. It looks like January 20th of 2026 to February 19th of 2026. As far as what he was previously on special parole supervision, he was sponsored by Fed Ahmad in Waterbury, and then he was at the Connecticut Renaissance Halfway House, Renaissance East in Waterbury. And then it looks like September 2023 to December 2023, did successfully complete the Community Solutions Halfway House program. He did complete 9th grade at Hill House High School in New Haven. He has had employment in the past. He had a full-time job at Connecticut Cellars in Oakville, which was through a temp agency. He had a full-time job at American Plastics in Waterbury, which was also through a temp agency. Full-time machine operator at Kelly Products in Waterbury. He was there for about 6 months. Then the building caught on fire. That's how he stopped at that job there. As far as his treatment, looks like December 2nd, 2025 to March 24th, 2026, he did participate in 7 classes of the Explore program, and also did residential episodes at the Abt Foundation Residential Division Inpatient Substance Abuse in New Haven. It looks like he did successfully complete that twice. He's also participated in treatment episodes at Wilmore Behavioral Waterbury, and also looks like December 5th to 2025 to January 15th to 2026. He did intensive IOP, and my social worker did receive documentation that he did attend 2 weeks of treatment there. And also looks like March 2026, he did participate in a diagnostic evaluation case management and 1 hour of intensive IOP with clinician Ms. Jones. He did report to us. He did successfully complete the Explore Domestic Violence program on, it looks like in January of 2024. So he has done that previously in the past. He's done some community service, passing out turkeys for Thanksgiving and toys for Christmas at the North End Recreation Center in Waterbury. He did sign up for work since he's been in the facilities. He's on the wait list for a chairman or a job in the kitchen, and he does attend church twice a week. He'd like to be sponsored by Ms. Slade again, as he indicated on the record. It wasn't the issue with Mr. Player, it was with the woman he was dating at the time, provided you with a current address and a phone number. He does want to obtain his GED. That's one of the things, one of his main goals. As he did indicate to us, he only has a 9th grade education, so he does want to obtain his GED. And he's amenable to all treatment opportunities in the community, and obviously wants to reunite with his 6 children and his 4 grandchildren. Mr. Player, anything I left out about your background or what you want to do when you get out? Is there anything you want to add? Now's your opportunity.
Yes, I want to further on with school, get my GED. Like I have some good people that's, depending on me. Like my sponsor, she was help a friend that's, if I get out, is going to hook me up with a job at Home Depot and, stuff like that, and continue with my groups and continue with finishing Explorer and Wellmore, like to continue with doing those things.
Okay, thank you.
Thank you. Have you taken any steps to obtain your GED?
Well, not since I've been here. I only been here like.
Did you in the community?
No, because I was so busy. Like I was in the halfway house. I was doing groups.
But they
twice.
help you with that in the halfway house. You can work towards that.
They have me doing groups twice on Monday morning, Monday afternoon, Tuesday night, Wednesdays, Thursday. I was doing like 5-6 groups a week.
Okay. I'm just saying, because you were out there 11 months, so I didn't know if you had started any type of steps towards
I was just
working.
I was working and doing groups. That was about it.
Have you done anything in the facility since you've been in there to address your substance abuse problem?
Yes. Well, we have NA in a church, and I just got a job yesterday.
So you telling me you're attending these meetings, or that they're just there?
No, I'm attending AA.
Okay.
And he was attending classes while he was on in the community there until he went off the grid.
Okay. All right, so I'll be right with you with the recommendation. Thank you for answering my questions.
Yes, ma'am.
All right, before I make a recommendation, I'm gonna put a few things on the record. I have reviewed all the evidence that was provided by the state. I've listened to testimony today. So, few things that I'm gonna note. You were in the community approximately 11 months before you absconded from supervision. This is your second time absconding while on this period of supervision that began in January of 2023. You were in the community approximately a month before you were apprehended by police. Your prior violations are for, on this period of supervision, were criminal and for absconding. So you did receive 6 misconducts before absconding, and what I have noticed is that it's the same behaviors that keep bringing you back that cause you to violate. So I'm seeing continued patterns of drug use, which we've discussed, alcohol use, and then you abscond. So you're still doing the same behavior over and over again, and you are on supervision until 2033. So you still have ways to go. So every time you abscond, you're stopping the clock on yourself. So I understand that you probably are aware of that.
Yes.
You can't complete supervision if you keep leaving, and we can't get you in treatment or help you out unless you stay with us on parole. So there are some issues I think that you need to address before you are released back out into the community, because these behaviors are concerning and have led you to get new arrests in the past and come back. So some things are definitely concerning because you still have these patterns that keep occurring. So and your officer is recommending an 18-month sanction. I've looked at prior violations. I've seen prior times you received about 8 months, 7.5 months about sanction. And the last time, based on everything that I read and we've discussed today, I'm going to recommend that parole be revoked. You be re-paroled for April 16th of 2027. This is approximately a year period confinement as a sanction. I recommend the following parole conditions: no consumption of alcoholic beverages, behavior management program for domestic violence, no contact with your victims, SW, LABR, LD without PO's permission, and general no contact with FA. My findings are going to go on the parole board on June 25th. So the board, as you know, can lessen the sanction, keep it the same, or make it longer. If the board wants a longer sanction than what I've just stated, you're going to come back for a supplemental hearing, and the board would talk to you about any reasons why they may want to exceed my recommendation. So just know that at any point, you know, the board can revoke special parole, all of special parole. So I encourage you to seek treatment while you're in there prior to coming out, regardless of what date you're re-paroled for. Do you have any questions?
No, thank you.
You will receive something in writing about a week after that date of June 25th from the board. So you will know your date that the board re-paroles you for, as well as your conditions. Okay? And I encourage you to seek help from parole instead of absconding, because it's not going to get you anywhere, you know?
So your recommendation is what, a year?
1 year.
Yep.
Parole officer recommended 18 months. As you indicated, this is not final yet, Yvonne. It has to go to the board on 6/25. You and I will get something in writing about 7 to 10 days after that with the final result.
All right, thanks.
Okay, any questions, just call our office.
All right, thank you.
Good luck, sir.
Good morning. Just 1 second. He's coming down now.
Thank you. Which inmate?
Give me 1 second. What are you guys looking for today?
I have inmate Moody and Beck.
Yeah, they're both coming down.
Okay, perfect.
So who do you want to speak with first?
Can I see Beck, please?
Beck first?
Yeah, he's gonna be
All
quick.
All right, no problem.
Thank you. Attorney Jones, are you there?
So we're gonna have yeah, this is me for
I'm here.
Okay, I'm gonna try to do him first.
Yep.
Woody's gonna go first. Okay.
Thank you.
So we're doing Moody first, correct?
Beck.
Oh, Beck, I'm sorry. Beck, so Beck,
Okay.
all right, so Beck will be the first one, and we're doing Moody after him. All right, he's on his way.
Thank you.
Hold on, Beck, hold on 1 second. That's what I'm saying. All right, so that's what you're doing.
Yes, sir.
All right.
Good morning, Mr. Beck.
Morning, ma'am.
Good morning. I'm just gonna go on the record.
Yes, ma'am.
Attorney Jones,
Yes.
go ahead.
Okay, thank you. In Mr. Beck's matter, I did have a conversation with him yesterday. Unfortunately, a conflict of interest developed in this case, and I informed Mr. Beck that we will be getting a assigned counsel appointed on his matter. He understands that we're asking for July 20th so that the assigned counsel can be appointed and have an opportunity to speak with Mr. Beck in preparation.
Okay, so I'm gonna grant the continuance for this revocation hearing for Mr. Thomas Beck, 299078, to the July 20th hearing date to complete the revocation hearing.
Thank you.
Is that correct, Mr. Beck?
Yes, ma'am.
Okay, so I'll see you on July 20th.
Yes, ma'am. Thank you.
All right,
Thank you.
Thank you.
Right. It is continuing.
Can you hear me?
Yes.
All right.
Thank you, Mr. Moody. Can you hear me?
I hear you.
Okay. So we're here today for revocation hearing, so we're gonna get started with that, okay?
Yes.
Good morning, I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Moody Donald, number 226335. Today is January 9th, 2026. This hearing is being conducted via video at the BOPP Central Office in Cheshire Correctional Institution. This is a public hearing and public access to the hearing is available via video live stream. Please state your full name and DOC inmate number for the record.
Donald Moody, 226335.
You have counsel here today to identify yourself for the record.
Yes, Hannah Dean on behalf of Mr. Moody.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact, each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weight of evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole and release you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all of the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You have a right to see the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
So we will now review the charge the state appeal is bringing against you and information underlying each charge. The charge 1, obey all laws, obedience to the law. Your charging officer reported on 3/19/26. You're involved in a physical altercation with your wife. She reported that you aggressively grabbed her, trying to force her back into the vehicle. Based on your actions, the University of New Haven Police Department issued a warrant for your arrest with the following new charge: a breach of peace. Second, your warrant was approved by a judge, and on 3/26/26, you were arrested by West Haven Police Department. On 3/27/26, you were arraigned at GA 22. You're in direct violation of parole agreement condition number 2, scheduled to appear before the Milford GA 22 court on 5/5/26 under docket ending in 9452-S for the aforementioned charges. And the state filed the following exhibits that were pre-marked for identification, which were exhibits A through J. There's no new evidence received by the state. Counsel, you did review all the evidence.
Yes,
Provided.
thank you.
And counsel has filed the following exhibits that are pre-marked for identification. Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue sharing to contain any additional evidence?
Not at this time.
We have no witnesses today. I did receive the addendum from PCS. The addendum reported on 5/12/2026. The breach of peace second charge was knowledge. So it's now a defense opportunity if you like to call witnesses, present evidence, and speak to any of the evidence submitted at this time.
Yes, thank you very much. As to the obey all laws charge, I would argue that there should be a no finding. This was a situation where the only pending charge, disorderly conduct, a Class B misdemeanor, was nullified in court by the state's attorney upon review of the case, consultation with the witnesses, and upon review of the available evidence. I do believe, speaking with the parties, that this was more of an misunderstanding than anything, and the complainant's reaction, I would argue, was more representative of her responding to her past trauma and anxiety rather than it was her responding to anything that my client did in that moment. I would argue that based on the entering of that nollie, in addition to the statement submitted by the complainant in this matter indicating that this was a misunderstanding and that my client never physically touched her in any way, there should be a no finding on that charge as the preponderance standard has not been met. Furthermore, I believe that we did note this at the preliminary hearing, but would just like to note again that at the time this situation occurred, my client thought that his PO was still P.O. Hawkins, and he did, I believe, take it upon himself to reach out to P.O. Hawkins on this date to update him about the situation, and he was forthcoming about it, which I do think deserves some consideration. From there, my understanding is he spoke to Parole, was placed on a GPS monitoring bracelet, and stayed with his father during the interim time. So he did, I believe, fully cooperate at that point with everything that Parole asked of him and was honest and forthcoming about the situation. Thank you.
Thank you. I'll be right with you with my findings. All right, so I am announcing my findings in regards to that charge. On charge one, I do find you violate conditional bail laws, obedience to the law based on the evidence that was provided. BFDH, although the charge is not, I do find the behavior meets the elements of the charge. So that includes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to this time.
Yes, thank you. I appreciate it. I would just like to start by noting at the preliminary hearing, I know there was a comment on the record by my client's parole officer indicating that he was a violent person. I did just want to start at the outset to note that I do take some issue with the characterization of my client as violent. Certainly the case he is on parole for is violent in nature. We're not in any way denying that. However, I would note that all the cases, that we typically see for juvenile parole review are of a very serious nature, or that review wouldn't be appropriate. I will just note that the seriousness of my client's offense was already considered by the board, and he was, despite that, unanimously granted release because he showed so much growth and change during his period of incarceration. His underlying crime did occur when he was under the age of 18, and consideration was given to the reduced culpability that's inherent in individuals under the age of 21 due to the juvenile brain science. The board also considered the last 32 years of his life, which truly has been a journey of self-reflection, remorse, recovery, and in many ways rebirth. And I would say that the individual you see in front of you today, my client, Donald Moody, is very, very different night and day from the individual, the young man that entered incarceration way back when he was still a juvenile. Additionally, I would argue he is a model inmate. He hasn't received any DRs in over 15 years. While incarcerated, he utilized and took advantage of all programs that were offered to him. He was able to utilize the DOC college program while incarcerated and completed several college courses and truly just focused his time on education, bettering himself and helping his peers. My client is 48 years old, born and raised in New Haven. He does have a very strong support system, including his mom, dad, his grandfather, siblings, and his wife. My client also does have a very strong support from his church community, and he has 3 kids and 4 stepchildren who are all present in his life. Most recently, when my client was granted parole back in 2022, he first went to live with his grandfather. He then was sponsored by his wife. And then he's temporarily, as I noted, stayed with his father until remand. Previously, while incarcerated, my client did obtain his GED, got over 40 college credits through the Wesleyan program, and also served as a mentor for various institutional programs, including AVP and Beyond Fear. When first released to supervised parole in 2022, my client was employed as a PCA through Best Choice Home Healthcare for about a year. He also worked for approximately 10 months at Amazon in Orange, Connecticut. He and his wife then established a flagging company called American Public Safety Association, where they teach and train aspiring flaggers. It is something where my client has made a focus of that business to put focus on individuals who are reentering the community from incarceration to help them find employment and get their feet in the door for future opportunities. He currently, as well, was working as an Uber driver for about a year and 8 months. He was doing individual psychotherapy on his own with a private provider. While on supervision, he did a bunch of different volunteer opportunities. He, I know, was working with his church, his Divine Will Fellowship. He spoke at the state capitol concerning parole. He also, I know, organized some benefit basketball games for his local community as well. He was on a minimum contact schedule. And upon reinstatement, he would like to be considered for being able to be sponsored by his wife at the address we provided. As a backup, we've also provided the address for his father. He is interested in going back to school to study photography and is very eager to return to his flagging company. He's open to any sort of treatment being recommended, including returning to his private provider, and is also hoping to continue doing what he was doing, sharing his story with at-risk youth in the community to help them avoid that sort of lifestyle. I am asking that you consider re-paroling my client on the first available date. He has been out since 2022. This is his first violation. While the community he was giving back and focusing on his time on bettering himself and helping his peers. I would argue concerning the contact with his wife, we understand that oftentimes no contact stipulations are put in place. I would just note concerning the letter that was submitted, I think it is clear that she does wish to have contact and doesn't have any ongoing concerns. And additionally, they do co-run a business together. Mr. Moody, is there anything I didn't include regarding your background, history, or your future plans that you want to say at this point?
No, you said everything.
Thank you very much.
Right, thank you for your statements, and I'll be right with you with a recommendation. Okay, so I'm gonna put a few things on the record. I've listened to all the testimony. I reviewed all the evidence provided by the state. So I will note, defender was linked to me approximately 3 years and 11 and a half months before his return to custody, was doing well prior to his return to custody on the new arrest, which did result in a nollie in the court system. There are no prior violations. He's issued 2 misconducts during this period of supervision. The offender did note the offender was in a serious, he's currently incarcerated and on parole for serious offenses such as murder, assault first, legal carrying pistol without a permit, and sale of illicit narcotic, in which he's serving 40-year flat sentence. After reviewing all of the evidence, and I did know all the great things the offender was doing in the community, was working, doing very well. So I take all that into consideration. So I am going to recommend that parole be revoked, that you be re-paroled for June 25th of 2026, which is my next available board review date. This is an approximate 3-month period of confinement as a sanction. I recommend the following parole conditions: no contact with your co-defendant, Jermaine Mitchell, Jermaine Smith, and Larry Smith, and Joseph Brett. No contact with your victim, FD, behavior management program for anger management. In general, no contact with WC, aka JB. This is without PO's permission. I'm gonna send this to the parole board so that they can hear this case on June 25th. So if the board agrees with me on June 25th, would be released that day. If for some reason the board did not agree with me that you would still be there and the board would want to see you for a supplemental hearing, and they would talk to you about any reasons why they may want to exceed my recommendation.
Donald, I'll set up a legal call with you so we can kind of debrief everything and I can answer any questions that you might have, okay?
Yep.
I am going to submit both sponsors that you provided me with, because it is up to the officer in the field to determine if he can return to the residence with his wife. He may be able to.
Okay.
It's all up to the field. If they're all working together, they may be permitted to return there. So,
Okay.
so I'll list, you want your wife as the first sponsor and your father as second?
Yes.
Okay. So I'll list both of those in there. And I wish you the best of luck, sir. You're all set for today.
Thank you.
Yep.
I
Oh, man.
Morning. Can you guys hear me?
Yes. Here, don't see you.
Mr. Howard?
Yes, ma'am.
Good morning. And P.O. Gerard, can you hear us?
Yes, I can. Good morning.
Good morning.
I have a question. Gerard's not my PO. Why is he here?
Because he's subbing in for the other P.O. today. All right, so, Gerard, can you just turn your camera on, please? We're gonna get started.
Sure.
Can we continue this? Because I am trying to get a new attorney.
Are you looking to hire a private attorney?
I'm speaking to Sonia Jones to get a different attorney.
From the public defender's office?
Yes.
Is this in the works or?
I'm
So,
Yes,
not
it
sure.
is.
all right, so Howard, so you're requesting a continuance, to,
I just,
Sonia said it'll take a couple of days, so I don't know what a couple of days is to her.
I could ask for continuous the next available date and I'll look into what's going on.
all right, let me, just see, my next available hearing date is the 17th.
17th.
Is that too soon or?
No, that's fine.
Okay. All right, Howard, so you want to continue it to the 17th?
Yes, ma'am, please.
Okay, so per the attorney and offender's request, I'll grant a continuance to my next hearing date of June 17th. And then we will see you at that time, sir.
Thank you, ma'am.
You're all
Have a
set.
good day.
Thank you. Have a good day, everybody. Good morning.
Good morning, how are you?
Good, how are you?
Doing well, thank you.
Is, Mr. Quiones there?
The Hall and Keone's are both en route. They should be here any minute. Would you like
Wonderful.
Keone's first?
Yes, please.
You got it, thank you.
Thank you.
You're welcome.
Thanks.
Good morning, Mr. Quiones.
Good morning, how are you?
Good, how are you?
I'm fine.
Okay, so we're here today for your
Morning.
revocation hearing. I have your attorney here, so we're gonna get started,
Morning.
okay?
Okay,
Good morning, I'm Theo Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Quiones Martinez Eduardo, number 220576. Today is June 9th, 2026. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing and public access to the hearing is available via video live stream. Please state your full name and DOC inmate number for the record.
sure. My name is Eduardo Quinones Martinez, number 220576.
Thank you. When you have counsel here today, can you please identify yourself for the record?
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, on behalf of Mr. Quinones Martinez.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole and release you, place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your appeal is bringing against you. I will review and identify exhibits filed for the record. The council will then have an opportunity to present all relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, council will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, so you have important rights today. Your right to have an attorney present and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes,
Okay. You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
yes, I do, ma'am.
Okay, so we will now review the charge the state your appeal is bringing against you and information underlying each charge. So charge one, the release restriction of absconder Your charging officer reported on 12/3/25, approximately 1:30 PM. You signed out of Connection House, halfway house. Your only parole-approved residence located in Middletown to go to work at Acme Burger. You failed to return at the scheduled return time at 10 PM. At 10:40 PM, you contacted the halfway house staff to notify them you will be returning soon. At approximately 12:52 AM, residential aid attempted to contact you. However, there was no answer. Local police departments and hospital were contacted, to no avail. The PO called and sent you a text message. However, you did not respond. Attempts to locate you via calls and physical attempts in the New Britain area were unsuccessful. Your whereabouts remain unknown. Also, you made no attempts to contact Parole or the halfway house since leaving on 12/3/25. Charge 2 under obey all laws, obedience to the law. Your charging officer reported at 2/11/26. You were apprehended by New Haven Police Department. At the time, you had an active arrest warrant with North Haven PD. The criminal charges said warrants for larceny fifth. Charge 3 under halfway house placement. Dates on 12/3/25 at approximately 1:30 PM. You signed out of Connection House, halfway house. Your only parole-approved residence located in Middletown to go to work at Acme Burger. You failed to return and scheduled return time at 10 PM. At 10:40 PM, you contacted the halfway house staff to notify them you'd be returning soon. At approximately 12:52 AM, residential aid attempted to contact you. However, there's no answer. Local police department and hospital will contact, no avail. This PO called and sent you a text message. However, you did not respond. Attempts to locate you via calls and attempts to the New Haven, the New Britain area were unsuccessful. Your whereabouts remained unknown. Also, you made no attempts to contact Parole or the halfway house since leaving on 12/3/25. And the state has filed the following exhibits that are pre-marked for identification as Exhibit A, remand in actual custody; B, parole violation report; C, PC assigned conditions; D, halfway house agreement; E, incident report dated 12/3/25; F, North Haven PD arrest warrant; F, RT60; G, RT67; H, rev hearing summary; I, decision information summaries; J, notice of parole violation; K, notice of parolee rights. Did you receive the notice of parole violation report, and those other documents that I marked, and did you review them?
Yes, ma'am, I did.
Okay, and council filed the following exhibit pre-marked for identification, Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses. I did receive an addendum from PCS. PCS stated in reference to the parole violation submitted by PO Grant regarding Quinones Martinez, the following applies. On 5/21/25, the Board of Parole issued a warrant based on the report declaring Quinones Martinez an absconder from special parole supervision. On 2/11/26, Quinones Martinez was apprehended by New Haven Police Department in conjunction with the Fugitive Investigation Unit. At the time of arrest, Quinones Martinez had an active warrant with the North Haven Police Department. Quinones Martinez was remanded to custody due to his special parole absconder warrant. On 3/25/26, the criminal case related to the North Haven arrest was resolved as detailed below. The charge of larceny 5th degree pled guilty when received a 6-month sentence. Currently, the EOS date on this new sentence is September 16th, 2026, with a TS eligibility date of 6/16/26. So it's now defense's opportunity. If you'd like to call witnesses, present evidence, speak to any of the evidence submitted at this time, you may.
Thank you. In regards to charge 1, as well as addressing charge 3, absconder and halfway house placement, the only comments that I have is that my client was in the community, gainfully employed, did leave on a work pass, and unfortunately came into a situation where he made a bad decision and he relapsed. That relapse caused him to not return back to the halfway house, and therefore the absconder warrant did issue. In regards to the obedience to the law, the addendum is stated accurately. So no further comments as to the charges, just would like to be heard as to his background and history.
Thank you. I'll be right with you with my findings. All right, so I'm going to announce my findings in regards to the charges. So regarding charge 1, I do find you violated the condition and restriction of absconder based on a warrant being issued by the BOPP and evidence that was provided in support of that charge, exhibits B, C, and E. Regarding charge 2, I find you violated condition obedience to the law based on your conviction of larceny 5th and received a sentence of 6 months jail. It's also based on exhibits provided by the state, B, C, and F. Regarding charge 3, I find you violated condition halfway house placement based on evidence provided in support of the charge, exhibits B, C, D, and E. That includes the fact-finding portion of this hearing. Before I make my recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you. My client is 49 years of age. He's single. He does have one child, a 16-year-old daughter. He does receive his primary support in the community by way of his aunt, Rosa, who resides in New Haven, as well as the church community. He does have his GED. He holds a certificate in human resources. Credits that he received while attending as Nantucket College include 30 credits towards an associate's degree. He was able to utilize the Second Chance Pell program while within the Department of Corrections. He was in the community, I believe, having been released initially to parole on October 10th of 25 for approximately 2 months. And during that time period, he was able to hold employment working at Parole restaurant located in Portland, Connecticut, working as a cook. He then transitioned to Acme Burger, located in Middletown, Connecticut, as well as was utilizing the Connection Halfway House program in Middletown as well. By way of treatment, he was attending NA meetings once a week. He reports working with a recovery coach for the past 2 years. During the time period that he's been within the Department of Corrections, he reports attending NA meetings as well, also attending church twice weekly. When he is re-paroled, he's asking to be placed in a halfway house in the Norwich, New London area. He does specifically want to go to the Fellowship House, which is located in Groton. I understand that's might not be possible, but he is asking for that Norwich, New London area. His future plans for parole reinstatement include he indicates he's amenable to completing an inpatient treatment program. He would like to successfully complete a relapse prevention group, as well as continue with 12-step meetings. He's certainly open to any employment opportunities. He has worked in the restaurant business in the past, and he enjoys working in that industry. We would be asking that he be re-paroled at a date not to exceed his EOS date on his new offense, which I'm not sure if you said it was 9/16 or 9/15.
9/16/26 as of today.
9/16. Okay, 9/16. So not to exceed that 9/16 date. Thank you. Is there anything that you would like to add, Mr. Quinones Martinez?
No, first and foremost, thank you, Sonia, for speaking on my behalf. Everything you have stated is accurate, and my desires to want to do good is true. And in New London, I set a good foundation in my recovery. Sadly, I relapsed, but I don't lose hope. And currently, I'm working on my recovery, being in the Time program here in Carl Robinson, and I'm reflecting on my mistakes. I see where I went wrong, and I hope to do better this next time I'm released. Thank you. That's all I got.
Thank you.
Thank you for your statements. I'll be right with you with a recommendation.
Sure.
All right, so I reviewed all the evidence provided by the state. I have listened to testimony today. There's a few things I will put on the record before I make a recommendation. You were only in the community you were in the community a month and 23 days until you absconded from parole supervision for approximately 2 months when you returned. you did return on new charges in which you received a new conviction and a new sentence for 6 months. And I have provided the US date, which was 9/16/26 on that charge. Excuse me, on that new conviction, which is a larceny offense. So what is extremely concerning, this is your first violation on this period of special parole supervision. However, you do have a history of absconding, especially you just absconded on prior discretionary parole right before, not too long ago, before you started this term of special parole. So there is a history of absconding, as well as an extensive criminal history of predominantly larceny and burglary related offenses that was noted by PCS. So what is concerning, as well as you are on supervision for larceny related offenses, numerous larceny related offenses. So the same pattern of criminal behavior seems to be continuing to special parole. And what's concerning is it happened so fast after you just were returned. So your officers recommended 12 to 18 months based on several of those factors. I am taking those factors into consideration, as well as the fact that this is your first violation on this period of supervision. And you do complete this sentence September 16th of 26. So I am going to recommend that parole be revoked and that you be re-paroled for December 11th of 2026, which is approximate 10-month period confinement as a sanction. This is an additional 4 months on top of the 6-month sentence that you received as a jail sentence for the new larceny 5th conviction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, no contact with your co-defendant, Tina Portino, mental health evaluation and treatment be necessary, and operation of a motor vehicle. My findings are going to the parole board on June 25th. So the board can agree with me. The board can let you out sooner. The soonest they can let you out, as I stated, is 6/25. That's the soonest date you can get out. They can let you out anytime in between the date that I've recommended or a longer sanction. If the board wants a longer sanction, you come back and talk to the board about any reasons why they may want to exceed my recommendation. And then, they'd have the opportunity to grant your re-parole date if they would like to. You are on special parole until November of 28. So you do have a good amount of supervision left whenever you're re-paroled. Do you have any questions, sir?
No, I don't.
Thank you. You're gonna get this in writing about a week after June 25th, after the board reviews your case and votes on your re-parole date. I hope that you get the treatment you need, because I do understand that your relapse is a factor. Hopefully that you will work on that so we don't see you back here again. Okay?
Thank you. I appreciate it.
Well, we wish you the best of luck, sir. Good luck with everything.
If you have
Have a
any
good
questions
day.
for Mr. Quinn, if you have any questions for me and you want to ask after the board review date, which is the June 25th date, just set up a legal call through your counselor, okay?
Okay, I will, Sonia.
All
Thank
right,
you. Have a
all
good
right.
day.
Good luck, sir.
Bye.
Good luck. Thank you, Attorney Jones.
Thank you.
Thank you.
Good morning, Hall. Mr. Hall.
Morning, yes.
Hi, we're here for your revocation hearing today.
Yeah.
So we'll get started with that. Good morning, I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Hall Donnell number 429139. Today is June 9th, 2026. This hearing is being conducted via video at the BOPP Central Office in the Carl Robinson Correctional Institution. This is a public hearing and public access. The hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Donnell Hall, 429139.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means releasing and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge that the state, your PO, is bringing against you. I will review and identify the exhibits filed for the record. You will then have an opportunity to present all relevant testimony. After considering all of the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure right now?
No, not right now.
Okay. You have important rights today, which I will now review with you. You have the right to have an attorney present at the hearing. Do you want to continue without counsel?
Yes.
Okay. You have a right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay, so we will now review the charge the state your appeal is bringing against you and information underlying each charge. So charge 1 on restriction GPS, your charging officer reported on the following dates and times you failed to charge a GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device on 10/4/25 from 2:19 a.m. until 7:16 a.m. and 10/6/25 from 4:52 a.m. to 2:50 p.m. Charge 2 under program participation. Charging officer report on 3/30/26, you were issued misconduct by this PO for possessing a vape pen within the halfway house. The sanction was extra chores, specifically cleaning the bathroom, as well as participation in the Courage to Change CBT program at the Watkinson halfway house. You refused to sign misconduct when presented to you on 4/1/26 and stated you will not be attending or participating in the group or doing extra chores. When the group session was called by halfway house staff on 4/1/26, you refused to come to the group room to participate. Charge 3 initial conditions halfway house placement. Your charging officer reported on 1/20/26, your assigned case manager addressed you on being 4 weeks behind on required substance to the halfway house. You were provided with a payment plan to assist you in catching up with payments, which you refused to sign. On 3/4/26, staff attempted to meet with you to collect pay stubs, required substance payments. You refused to present your pay stubs and owe approximately $550 for 4 weeks of failing to pay. You then swore at staff when they attempted to address you on this, saying, "Stay the F out of my business. I'm tired of all your mother effers." On 3/5/26, you signed out of the Watson halfway house at 7:30 a.m. for work with a return time of 5:40 p.m. You did not return until 7:40 p.m. You did not call prior then to state that you would be late. On 3/8/26, you repeatedly swore at front desk staff after they called short time. You stated, "Shut the F up" on the F and intercom. I'm talking to you, shut the F up. Upon another staff addressing you on the situation, you stated, "Tell her I said F you." This is in violation of your signed halfway house agreement. On 3/30/26, while conducting an informal tour of the halfway house, staff observed you in the bathroom with 2 other offenders. The staff observed smoke in the air. Upon completion of a pat search of your person, you're found to be in possession of a vape pen. This PO had previously given a direction in a health meeting on 3/27/26 to not smoke or vape in the bathroom, and this behavior was a blatant disregard of that direction. On 4/10/26, you were observed by staff during their tour to be inhaling a marijuana joint in the bathroom and then go to the toilet and flush it down when you observed staff entering the bathroom. And the state has filed the following exhibits that are pre-marked for identification. F, Exhibit A, notice of parole violation. B, notice of parole rights. C, remain in extra custody order. D, PCS signed conditions. E, GPS monitoring agreement. F, LL universal charging history. G, offender misconduct. H, halfway house agreement. I, residential disciplinary report. J, offender misconduct. K, residential disciplinary report. L, offender misconduct. M, incident report. N, offender misconduct. O, residential disciplinary report. F, misconduct. Q, residential disciplinary report. R, incident report. S, offender misconduct. T, incident report. U is also incident report. V, offender misconduct. W, decision information summaries. X, rev summaries. Y, parole violation report. Did you receive notice of parole violation report, and those other documents I marked? And did you review those?
Kinda. There's some reports that you just stated that I didn't even get. So,
It should have been in that package
yeah,
that you received. All the stuff was in the package.
I'll go reread it.
Well, do you want to continue with the hearing?
Yeah,
Okay. There's no witnesses today. So now is your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you so choose. If you do want to provide testimony, I do need to swear you in under oath first.
okay.
So please raise your right hand. You solemnly swear or solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Okay, so would you like to respond for the charge that I just read?
Yeah, so, the first charge that was GPS, the GPS charge, my charger had a shortage and they knew that. So I'm not understanding how I got a charged with that when I told them and called them and told them that my charger had a shortage and they provided me a new charger and I had to sign for it. So I don't understand how that was an actual charge to me, considering that I got do that the next day after that, and then had to get violated for it 6 months later to the day. My freedom of speech with everything else seems to be valid.
What did you say? Your what? What did you, I couldn't hear you.
My freedom of speech.
Okay.
When it comes to my dialogue and to the other staff members, that's just how I felt at the time. I don't know what to really explain for that, but I didn't know such thing as so much as a criminal act as like threatening anyone or anything. So I don't see how that's a violation. If I was to tell someone to be quiet, that's just my expression. It didn't have to be aggressive. It could have been out of positive. But I know next time I'll say shut the front door. As to subsistence, it was already hard for me going through winter with a minimum wage job and having to pay that subsistence. I couldn't pay for it. I couldn't do it. I even tried to maneuver jobs, try to find a new one. And as soon as I did that to try to help your plan, the payment plan, they didn't like that. So I don't know what to say about that one either, because they didn't want me working at the job I was working at before. So I tried to get my 2 weeks notice and get a new job. And they didn't like that. And I didn't even get to do it for them because I was remanded. So I don't know what to say about that one. That's all I have to say to that one. And just all in all, I get the fact that I have a substance problem when it comes to smoking. Though me being here and not going through the timeout program didn't make it better either. So I'm not understanding what that's about either. So I don't know what to say about that one as well. But everything else sounds like a blur. That's all I have to say on the subject.
Okay. Well, thank you. I appreciate your statements, and I've noted what you have stated. So then I'll be right with you with my findings in regards to the charging. Right, so in regards to charge one condition, I do find you violate condition GPS based on evidence provided, D, E, F, and G. Regarding charge two, I do find you violate condition program participation based on evidence provided, D, U, and S. On charge three, I do find you violate condition halfway house placement based on evidence provided in support of the charge, exhibits D, H, J, K through U. So that includes the fact-finding portion of the hearing. Before I make a recommendation, you will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So at this time, if you'd like to say anything in regards to your background history, anything you've been working on, any future plans to go back out, now would be the time to talk about that.
Well, I would say I am, regardless to all of that, you say I am a nice man and a hard worker. I don't even try to make problems with people. I do my best to do things the right way. I don't consider myself lethargic or even so much as lousy. I do what I have to do. I try my best to keep things uptight and proactive and prominent. I don't like to be accused of something I didn't do. And for some things of these charges, it sounds a little ridiculous considering that these aren't really like my type of causes. When you said about me being late, coming back late to a halfway house, there was probably a big reason for that. That shouldn't even be of things for me to be validated for. Probably my phone was dead, or it wasn't on, or I had to stay late.
So when we're in the halfway house and you have rules in the halfway house, which you signed when you came in, if you don't comply with them, you can be violated on them, which is why you're back.
Yeah, and I understand that. But
there could be reasons, but if there was a reason, then it should have been dealt with at that time so that was excused. If you were on the phone and you were talking, or you called staff, there's certain policies to follow. If you followed it, then you wouldn't be here.
Yeah, and it sounds like, and I call, if I was to come late from work, I will call you guys. I will call the halfway house straight up and be like, hey, I'm coming late. They probably didn't answer at the time, or I was running really busy during my shift and couldn't even do that because I had to work overtime. There's no other reason why I would come 2 hours late back to a halfway house and then not have to suffer the consequences. Like, that's not me either. That's not me either.
So what's your plans to go back out? What's your future plans to go back out?
Well, continue employment. I did get put in a 2 weeks notice from my last job to go get a higher paying job, so I can be able to pay assistance and do all the things that I needed to do for the halfway house. And not only for that, but self-housing. I try to get self-housing, just try to do.
You have that now? Like, do you have a sponsor right now or no?
I do. I was kicked out of my sponsor for no reason to come back into a halfway house. They didn't tell me the reason why. They just threw me back into a halfway house and didn't give me an explanation either.
So right now, do you have a sponsor now?
Yes.
You're saying it's the same one? Is it the same one as before? Or is it a new one?
I have three. I have one that's in state. I have one that's out of state.
Well, I don't want out of state. If you were, it would need in state.
It would be my emergency contact.
So I need your sponsor's information if you want to go there.
I would.
Now, do you have it right now?
679 Pine Street. 679 Pine Street, Middletown, Connecticut, 06557.
Who is this?
Melissa Millardo.
How do you spell the last name?
Millardo, M-I-L-A-R-D-O.
And who is that in relation to you?
This is a friend.
Friend. And is there a phone number?
Yes, but I don't have it on top of my head right now. Can I come back and
Can you
And
get it
like-
to your correctional counselor, as soon as possible and have them send it to parole?
Yes, ma'am.
Say, parole officer Meisinger with the board,
Parole officer,
Meisinger.
my senior.
That's my last name. I need that, phone number.
Alrighty.
Okay, so do you have a job when you are you saying, is there somewhere you're going to apply or?
I have a job. I can go back to my job. I have a job, my Burger King job. I'm still there, but I was in the middle of transitioning. So,
Okay.
I can still, I'm able to get a job still.
Is there anything else you plan on, do you have a medical marijuana card?
No.
Or do you understand though, if that you had to go back to a halfway house, that you cannot smoke in the halfway house? Do you,
Yes.
for safety reasons, you can't smoke in a halfway house. That's why you can't do that. So you do understand that. I understand that you're saying you have, a lot of people are addicted to smoking, but you can't do it inside the house.
Yes, ma'am.
Is there a problem with that or?
No, because I can stay sober. I can.
Okay. Is there anything else you want to say in regards to going back out, things you want to work on, at this time or no?
I just want to work on, besides working on myself, just getting back to my family and friends. I don't have much time.
No,
I
you
don't have much
don't.
time here.
Yeah.
So I just want to get, do right now. If it's the last couple of months I have to do right, so be it. I will do right and just get to the next level because I'm not here long. I'm not in the system much longer. So I just want to do things right and
Well, we hope. Fingers crossed.
yes.
Yeah.
Yes, ma'am.
All right, so I'm gonna put a few things on the record and then I'm gonna make a recommendation if you're done with everything. Okay, so I reviewed all the evidence provided by the state and I have listened to testimony today. You were on special parole approximately 2 years and 9 months before you returned to custody, so you were out there for a while. You were doing well before your placement in the halfway house. We talked about the issues that you had in the halfway house. You do understand if you had to go back to one, that you would be compliant in the areas we talked about, correct?
Yes, ma'am.
If they did have to put you in one, what area would you want to go to?
I'll go back to Hartford.
Okay.
It's not New Haven.
Okay. You do a prior technical violation. You were issued 7 misconducts during this period supervision. Based on the information I have, I am going to recommend that your parole be revoked and that you be re-paroled for August 13th of 2026, which is approximately 4-month period of confinement as a sanction. I'm leaving you approximately 3 months remaining for community supervision in the community before you are done with your special parole completion date. I recommend the following parole conditions. In the event that I don't get all the information required, you can't go there because of the short amount of time. I am going to put halfway house placement on there in the event you can't go to the sponsor. No consumption of alcoholic beverages, mental health evaluation and treatment deemed necessary, behavior management program for anger management, no contact with your victims AE and JW, and no contact with your co-defendants DeAndre Brown and Dominic Matthews. I'm presenting your case to the parole board on June 25th. So the board's going to review this on that day. They can let you out sooner if they want. They can let you out as soon as June 25th. That's the earliest date. They can let you out anytime in between. They can agree with my recommended date that I gave you for August 13th. Or they can revoke all your special parole. If they do choose to do that, you'd come back for a supplemental hearing and the board would talk to you about any reasons why they may want to exceed my recommendation. Just so you know that is a possibility. Do you have any questions?
4 months.
Yes. You have a prior technical violation as well for similar behavior. So I'm trying to give you a chance to go back out before you're done with special parole to get stuff straight. So instead of revoking it all. So you'll get this in writing about a week after June 25th. That's when the board's looking at your case, what their decision is. So it'll be in the mail for you. Just make sure you see that. And the officers will be in contact with you if they re-parole you.
So I don't have to send you a number.
Nope, you don't have to do anything. You're all set. You'll just check in the mail after June 25th. Okay, so you're all set, sir. I wish you best of luck out there.
Thank you.
Have a good day.
You too.